Hi, this is Patrick Conroy, and this is trial preparation post-discovery to pretrial. So, we've collected our evidence. We got the depositions we needed. We've gone through the documents, found what we needed, done the physical and mental examinations as necessary, got the witness statements. Everything's sort of done on our end as far as collecting evidence. Now, we get into the trial preparation, post-discovery to pretrial. So one thing you have to do is identify and distinguish between legal and factual issues for trial. So a factual issue would be, did she run the red light? A legal issue would be the law and also, case law on the issue. Okay, legal issues, these are points of dispute on which law is applicable and or how the law should be applied. Now, maybe if you saw, a court case on TV, you see them quoting case names. Well, what they're doing is saying, hey, this is what the court already looked at an issue similar to this in this case, and this is how they rule. So stare decisis. Or it could be that it's, from an upper level court, so they have to follow a precedent. And these could include procedural issues, which include things like gathering of evidence, objection to whether they should have to provide something or not, or substantive issues related to whether this law is applicable in this situation, or whether there's a case that overrules the case that the other person brought in. Facts are facts, and they are either actual or alleged events and occurrences. Parties may stipulate to the facts. We saw that, maybe we admit to some facts, we'll deny some other facts. It's good to just get that out because it saves time and money and has a positive impact on jurors because they know you're not trying to waste their time. So, you're gathering all this and you prepare a pretrial memorandum. It's a document that's a summary of the case prepared as a guide for the trial judge on what the issues are, the disputed issues, what the areas of agreement of counsel are, and how long you estimate the trial will take. The judge has to fit this into a calendar. So this is all several days or a week, sometimes 2 weeks before the actual trial. The trial brief is a document presented to the court setting forth the legal argument. So when I talked about the legal issues, to persuade the court to rule in a particular way on a procedural or substantive legal issue. And both sides put in trial briefs. It's a big issue, what lawyers study in law school to be able to do. It presents the statute and case law that support the position for admission or exclusion of the evidence, or it could be permits judge to rule on as many of the procedural, substantive, and factual stipulation issues as possible before the trial begins. So this will save time if he can, go through some of these and say, no, this case doesn't apply, this case doesn't apply, and go through all those pre-trial. Okay, now describe the purpose of doing a cost-benefit analysis of a lawsuit. Really, when you're working with your client, this is something that you should be doing all along, with every step, really. Because the cost-benefit is a process by which the litigant determines the cost of pursuing litigation and compares them to what is likely to be gained. So, really, this should be brought up way at the beginning of the case and also before you head into the courtroom and several times in between. Because, you have to be honest with them and say, like, hey, this is going to be your cost. This is how much you're likely to get. And is it worth it to you? Here are some of the factors. Here's the probability of winning or losing, the amount of money to be won or lost, all the attorney fees and other costs that have come up, and also the additional fees that will come when we actually go into a courtroom, and the long-term effect on reputations, including the client's own, and the relationship of the parties. Your sister will hate you forever. So these are things that, you really have to have a sit down and talk to. Some other factors are the amount of prejudgment interest, the psychological cost of litigation, how unpredictable the legal system can be. Sometimes jurors just don't like you. Possibility of error, loss of time by managers and others that are going to be brought in, and whatever factors are unique to the parties. So you really want them to be sure that they want to go through, because now is when you might be getting settlement offers as well. A lot of cases are settled right at this point. And we'll come back to the rest in a minute.